Salutations, respected viewers. This is George from Ireland, carrying on my series about English law, also called common law. So this video is going to introduce the law of property. So property law is an area of civil law, i.e. non-criminal law. I don't mean it's an area of Roman law. It's in Roman law as well, but we're looking at English law. So the law of property matters because we all own things. So it relates to possessions. However, when we talk about the law of property, we mean primarily land and buildings. Real property, we call it, or realty, as opposed to personalty, as in chattels, personal effects, movables. Property law also governs intellectual property. So we will touch on that slightly, but we're primarily looking at real property. Intellectual property, that's to say, supposing you published a book and it's copywritten, then you have copyright. Royalties are paid to you. If somebody wishes to make a film based on that, then you get royalties, you get money from that. This applies to songs, photos, inventions you patented and so forth. That's what they're patent attorneys, or special category of barristers to do with that, or some are to do with chemical formulas for medicines and so on. But as I say, property law is chiefly concerned with land. Why is this so vital? Well, we all use space. It's finite. We often walk across public property. We own a house, or else we rent somewhere to live. Businesses rent properties, things like that. So property has immense value, and in that sense, property cannot be lost. I suppose there's erosion under the sea. And can bits of the sea be privately owned or only leased? Well, that's another vexed question. So pretty much land will always exist and in the same location. Land is exceptionally difficult to steal. There have been examples, but in a country with rule of law, it's all but impossible to steal. So that's it. Realty, we're really looking at land and buildings. That's why people who deal in real property are called real estate agents. Usually in England, it's just simply estate agent. In the United States, they're often called realtors, those who are arranging the sale and purchase of real property, occasionally the rent of real property as well. So real property is sometimes called immovable property, since land cannot be moved. Buildings can occasionally be moved. I mean, there are porter cabins or whatever. All right, so personalty are personal possessions which can be moved. That's separate. We're not going to look at those very much. So how did real property come to be? Well, humans, we started in the Rift Valley about 3 million years ago, and somebody must have said, this bit is mine. Somebody staked a claim. It's fascinating to trace back, how did property come to be? People seldom work out, there must have been a moment when nobody owned anything, and then gradually property emerged and people pushed others off the land. Anyway, that's why we say possession is 9/10 of the land. So some land was never owned by anybody. Now, there was this terra nullius principle. It's a Latin expression, as in nobody's land. You could translate it, or perhaps empty land. So that land is treated as though nobody owns it. This was used extensively by British colonizers in the 19th century. So they landed in Australia, well, began to settle Australia in 1788. A gigantic country. It's now got, my goodness, 25 million people or something like that. Back then, it's estimated to have had 500,000 people. Even now, vast areas of it are empty. So the British government went by the principle that this land was devoid of inhabitants, which wasn't true. Some areas were inhabited. But anyway, the British immigrants could simply claim bits and say, this is mine. And that terra nullius principle was used elsewhere by the United States during, what was it called, Manifest Destiny, their westward expansion. All right, sometimes they purchased lands from Native Americans. Sometimes they made deals. Other times they were simply seized. So the Aborigines were nomads in Australia, and Britishers claimed that they didn't have a concept of a fixed dwelling place. They had no territorial boundaries. That's not quite accurate. The Aborigines seldom practiced a sedentary lifestyle. They didn't have much settled agriculture. So Britishers assured themselves they could lawfully take possession of this land. Population density was certainly very low. So was that a reasonable argument, that legal argument, or was it self-serving drivel? You decide. Supposing you arrive in an island that's not on a map. And there are no people there, nor is there any indication of human habitation. No huts, no fences, nothing like that. Would it be fair to assume this island is empty? Could you claim it as your own property? If yes, you accept terra nullius. If not, why not? Was it wrong of anyone to claim property at all at the dawn of mankind? Anyway, if you're claiming this island, would you be allowed to claim the whole island or half of it or what? Anyway, so these are some of the deeper philosophical questions provoked by the very notion of the law of property. Now, coming on to law and equity. So the law of property is divided into law and equity. So law is more formal and governed by statute. Equity is more informal and it's governed chiefly by certain equitable maxims that judges have come up with down the centuries. So it's really tricky what's law and what's equity and property. So there's a renowned legal maxim that whoever owns land owns it from hell all the way up to the sky. So supposing you own land and you discover there's some precious minerals beneath it, that's yours. It might be of negligible economic value, just desert, and then turn out that there was oil underneath it. And people are not allowed to build structures which overhang your land, even if the structure doesn't actually touch the ground on your land. People are not permitted to fly too low over your land. And I suppose it comes on to sort of national property and airspace. You own any wild animals that come onto your land, de ferae naturae. That's the Latin expression, as in of wild nature. But once that wild animal's gone onto somebody else's property, you don't own it anymore. You can't shoot it, anything like that. If somebody's pet wants onto your land, you don't own it. Okay, you're not allowed to claim it. How do we tell what's a pet, what's not? Well, that's where it gets a bit tricky. Supposing Simone is a farmer and her cow breaks the fence and wanders onto Angela's farm. This cow does not legally belong to Angela. Sorry, it wasn't a pet, but it was an animal that was owned by someone. It's not wild as a farm animal. So land ownership. There are various different types of land ownership. The supreme one is fee simple absolute in possession. So some people own freehold property. That means they absolutely own it forever. Most people own leasehold property, which means they own it for a slice of time. But this can be an extraordinarily lengthy slice of time. The minimum is usually 49 years. More commonly, it's 99 years, occasionally 499, even a year shy of 1,000. So obviously the value of the property goes down as the lease is running out, but the market price might be going up. Supposing you bought a 999-year lease, next year you've only got 998 years left. Will the property really go down in value? Well, it might even go up if the overall price goes up. So the law of property pertains to inheritance. A person makes a will saying that when he or she dies, what will happen to his or her property, real property as well as movables. So property law crosses over with family law. So there's several different subjects within law. Don't imagine that they're strictly demarcated. There's a very considerable overlap between them. Equity and trusts, again, overlaps with the law of property. A legator is someone who creates a trust to administer the inheritance that he or she is leaving to his or her heirs. I think I won't bother with the feminine pronouns. As I've said, be it understood, this includes the feminine pronouns when I say he. A legator is the one who creates a will, and a legatee is the person who inherits the property or legacy. The property can be realty, personalty, a combination of the two, money in the bank. So the Trusts of Land and Appointment of Trustees Act is a pertinent statute to property. So is it possible to disinherit one's children? Yes. Supposing there's someone named Stephanie and she falls out with Iskander, who's a total ingrate, she could choose to give him not a bean in her will, and she gives everything to her friend Janori. So that's the way it goes. We often come up with these educational examples. Whereas in Scotland, someone is not permitted to disinherit his or her children. The person can give all the property away whilst alive, but he cannot in his will say, no, I'm not going to give anything. If he said he's not going to give anything to his children, it would be null and void. They will always inherit at least a little of their property. Quite how much is the minimum, I don't know. I've never studied Scots law. So some people die without making a will. They're said to die intestate, because often they say the last will and testament. Your testament is like your statement, because the beginning of the will, there might be a preamble when you just express your affection to those you're leaving behind. So people often establish a trust to administer their property whilst they're still alive, so that when I die, you'll run my estate. Your estate can mean your land, that sort of estate, or could mean the money you had in the bank, the investments, could mean royalties from that film script you wrote, whatever it was. And the purpose, so you can give away all your property to your heirs before you die. And supposing you give it away more than 7 years before you die, then you avoid death duties, as in taxes. Trouble is, you can't be certain when you're going to die. So most estates attract inheritance tax unless they're passed on over 7 years before the person dies. There's a minimum threshold. The value of real property going up, that means more and more people having to pay death duties. So someone writes a testament with their will for the most part. That's completely optional. And it may govern how the funeral is to be held. However, that is not legally binding. Hyacinth may say she wishes to be buried, but her daughter has her mother, Hyacinth, cremated. This will not disbar the daughter from inheriting the legacy. So wills can be written with the assistance of a solicitor to make sure they're legal and recorded. A person can write a will informally, and this is legally binding, provided will can be sure that it was genuine and the legator was compos mentis, as in of sound mind, when he or she wrote it. Indeed, in many estate agents' shops, news agents' shops, there's a DIY will form to help you. A person cannot inherit debt. There's no longer this sort of damnosa hereditas. However, an estate can inherit debt. Reem dies and she leaves her house to Aisha, her sister. The house is worth £500,000, but Reem's debt is £600,000. Aisha could choose not to accept the house, because if she accepts it, she's also responsible for the debt. Now, why on earth would anybody choose to accept an inheritance which meant that they'd be £100,000 in the red? Well, Aisha might be able to have some of the debt written off by the bank. She might be able to reschedule the payments over a very long period. The house might suddenly appreciate in value. She might be able to rent out the house and help her pay off the debt. There might be some sort of sentimental value to the house, things like that. So there are all sorts of reasons why people might choose to do this. All right, that's enough for the moment.